reason it doesn't want to work. So I'll have to find a solution before the next lecture. We will continue the lecture for the next 3 hours. What I'd like to tell you all is welcome to the course. I hope that if you want to write for this current exam, that you have contacted our association and that you have all registered timeously. Please bear with me with the phone because I have to hold the phone and I've got to work out what my background and everything else is. Can you all hear me?
Yeah.
Okay. All right.
Okay. All
People,
right.
we are recording
We
the
are
session,
recording the session.
so hopefully you will all receive, you will all have an opportunity to obtain a copy of the session in the event that we are not, we have a problem with electricity and if my phone runs out of power. Okay, so this is the notarial practice course. Please check with our Law Society, Legal Practices Council, as it is now called, to determine when the exam is, when the last day is for you to register for the exam, and for you guys to make payment for your exam. So please, please make sure that you register timeously and you pay all the relevant fees for the course. Otherwise, we have a problem. Okay, I can't switch off all of your videos. So please, if all of you could switch off video, it would be great. I'm trying to see whether or not I can put a background up, but I can't at the moment. All right, I'm going to turn off all incoming videos. Perfect. Now, in respect of the course itself, what do you need to know? What books are available to you? Well, our notes are very comprehensive. We try and make them as comprehensive as we can. Hopefully you will have received the notes. You will have received the legislation book. And in addition with the notes, the legislation book, you have annexes to the notes. And we also have a note handout. Purely because I am not able to see you personally in lectures. So I've provided handouts which will assist you in preparing for the exam and familiarizing yourselves with everything we have. What are we going to deal with? Well, we are going to teach you with types of documents that you have to prepare as notaries public, the documents you have to lodge at deeds offices, how to draft the documents, and hopefully your drafting skills are going to improve. We also have assignments for you, and our assignments are constructed to assist you in working out how to answer questions in the exam. Ultimately, at the end of the day, if you follow what we tell you, you work with the assignments, you go online to the platform and you pick up all the exam papers and draft again. You should be prepared and you should be able to pass the exam without an oral. Now, in order to pass the exam, you have to have, without an oral, you have to have an average of 50% and above. In my days, you had to have an average of 70% and above when I wrote the exam. Okay, so it might have been 2 decades ago, but that's another story entirely. But the point is, at the end of the day, if you get between 40 and 49%, you have the opportunity of having an oral. Please, whatever you do, do not forego the oral. Attend the oral, because the oral is very important. The examiners want to determine whether or not you had nerves in the exam and answered incorrectly, you ran out of time, and they want to see what your knowledge is. And basically, they question you on the exam paper. Passing rate isn't always the best. However, you should be able to pass. Should you follow what I tell you, you should not fail. You should pass the exam. Again, this is a drafting exam. You receive nothing in the exam. You need to know your work. Can you spot? No, you can't spot. The exam is everything. You will see from the kind of questions we give you in the assignments that there are various aspects of the course that appear in one question. You might not just get a specific module that is asked. There are questions that comprise all the modules that you've dealt with. So you cannot skip anything. The moral is you've got to follow a procedure in order to prepare yourself for the exam. Obviously, the first lecture is very difficult for you to prepare in advance because you don't have the notes and you're not sure what needs to be done. But this is the way we're going to work on the lectures. We might have to proceed extra time on the lectures in order to catch up everything. We used to have 4-hour lectures, 4.5-hour lectures. Our lectures are now limited to 3 hours, but we may proceed longer than 3 hours. So if we have to do that, you need to be patient. I'm going to try and fit everything in. Please understand there is so much to this course. We are going to try and cover the first 3 modules in this lecture. In other words, we're going to deal with drafting, the manner in which you need to prepare your documents, the manner in which you have to describe parties, and what your documents need to look like. We deal with drafting certificates. You will find that the majority of your work deals with certificates. And we also deal with antenuptial contracts. Of course, the antenuptial contracts are we might not have enough time to finish. The first assignment that you will receive with your annexes and notes is due for next week. My suggestion is please attempt it. I need you to read up all the notes that you have that we deal with this week. In other words, modules 1, 2, and 3. And for the following week, modules 4 and 5, which deal with 4, 5, and 6. Sorry. It deals with donations, trusts, and wills. The week after that, in other words, in week 3, we're going to deal with notarial leases and notarial bonds. In week 4, we deal with servitudes. You're going to say servitudes. If you look at the notes, our servitude module is short, but the annexes to the servitudes are long. You are expected to read through them. Why? Number 1, because it gives you an idea of what drafting notarial deeds is all about. And 2, it's going to help you understand the different aspects we have in relation to notarial deeds. So, last week, we're going to deal with whatever overflow there is and that we didn't deal with. We're going to deal with negotiable instruments, and with taxation laws. I'm going to touch on taxation laws as and when everything and anything is relevant with the module that we're dealing with at that moment. I will also in the last lecture try and go through examples with you, past papers, and point out things that I believe you need to be familiar with to assist you in working with notarial deeds and in to assist you in writing the exam and passing the exam. That is the motivation we have here. You need to pass the exam. We need to ensure that you are in a position to pass without having an oral ultimately. Now, what legislation do you need to worry about? Well, there are plenty of acts that you need to be familiar with. And we've got that in the notes for you in the notarial practice syllabus. If you have a look, it's the same. It hasn't changed. Books. Now, that is a difficult topic because there are no current books in print. The only book that we have that is mainly up to date and isn't really up to date because there are quite a few problems on it. Sorry, I'm trying to get my phone at a position where I'm not looking down on the phone. So books, what can I say? Most of the books are out of print. So if you're able to look at if you have a library available to you, a legal library, you need to borrow one or two of the books that you find there. There's Van Zyl, The Notarial Practice of South Africa. These are all old books. There's Lewis, Legal Ethics. I don't need to stress the ethics aspects for you. Fundamava is the latest publication. It comes in English and Afrikaans. The course is given in English, so please understand that there isn't that much we can do. I cannot provide you with Afrikaans terminology. I can try, but my recommendation is you write the course in English. The Deeds Registries Act is one of the most important pieces of legislation for us. There is a piece of legislation, obviously the Sectional Titles Act, Sectional Schemes Management Act, the Trust Property Control Act, obviously the Legal Practices Act, Long-Term Insurance Act, the Children's Act, Interstate Succession Act, Administration of Estates Act. You're going to say, why is that important? Because we deal with wills. There are a lot of aspects that we are going to be dealing with, for example, wills, for example, donations, and even trusts, where the work used to entail the necessity of having notarized documents. That no longer occurs. So the problem we have today is that your ability to act as a notary public has been diminished quite substantially. You will find the majority of the work that you deal with are drafting antenuptial contracts, probably servitudes of some sort if your office deals with any form of subdivisions and the like, and of course sectional title. We will talk about the Sectional Titles Act and the extent to which you as a notary are entitled to prepare documents in terms of that act for lodgement at the Deeds Office. Formalities in respect of Leases of Land Act, Matrimonial Properties Act, the Transfer Duty Act, Security by Means of Movable Property Act, and the most important act that you will ever have to deal with, and I'm serious, Subdivision of Agricultural Land Act, which has been repealed. However, the repeal has not been promulgated, which means the act is in full force and effect. Now, the questions in the notarial exam are never tricky questions, all right? However, they do not hesitate to ask you questions that deal with immovable subdivision of Agricultural Land Act. Now, before I go into anything further, let me just give you a little bit of background on the Subdivision of Agricultural Land Act. Subdivision of Agricultural Land Act came into effect in 1970. Basically, what it did is it took farmland and said you cannot subdivide farmland. Full stop. Not more than one person may own farmland. Full stop. If you're married in community of property, obviously you have an undivided half share in an estate. So as a joint estate, you can own immovable property that is farmland. However, you may not subdivide it. So it becomes very, very tricky when dealing with wills and how you dispose of farmland in a will when you have more than one heir. So that, I must tell you, has come up quite a few times in the past. We've had a lot of questions that have come up in the past. Servitudes, always get asked servitudes in the exam. You will always get asked a notarial bond in the exam. You will always have a question in respect of an antenuptial contract in the exam. you will have a question either on drafting a certificate in apostille, which we will deal with shortly, and or a bill of a bill of exchange, a negotiable instrument. You might have a trust to deal with, or anything to do with a trust. You might have a long-term lease to deal with, or anything to do with a long-term lease, the registration of a long-term lease and the like. So the issue is, at the end of the day, how do we go about sorting all of these issues out? So we're going to start off with, what is notary? What is the function of a notary public? And why do we need a notary public? Well, a notary public is an independent legal person. You have to have been admitted as an attorney. Please note, so those of you who are candidate attorneys and are doing this course and pass the course and bring your application for admission as an attorney, must do your application for admission of attorney first, and you follow it in the same papers with a request for application as admission as a notary. Because one of the allegations you have to make, either as a notary and a conveyancer for your admission, is you have to state that you have been admitted as an attorney. You are not allowed to be admitted as a notary or a conveyancer unless you are an admitted attorney. So please bear that in mind. In our papers, in Module 1, we have provided you with a draft application based on the new Act on admission as a notary. So do not follow it religiously. Please, whatever you do, whenever you do anything, always look at the Act. Always look at the Act. Follow the Act. This is just a guide for you, all right? Everyone's circumstances differ. So whatever happens, make sure you set out the facts, put in all the details, add all your annexures, and do the necessary documents. Now, the position of a notary public is a very old office. It's not something new. It's been in existence for over 1,000 years. And the definition of a notary public, as per the Deeds Registries Act, is as follows. Notary public means, in relation to any deed or other document creating or conveying real rights of land, a person practicing as such in the Republic, and in relation to any other document executed outside the Republic, a person practicing as such in the place where the document is executed. Now, what does that mean? It means, as a notary public, you can practice throughout the Republic of South Africa. Now, because of the manner in which commerce operates and the way people have moved around the world, we find ourselves in situations where we have to send documents overseas for use overseas, and we have clients who live overseas who have assets in South Africa and require to deal with those assets, and they will send you documents in South Africa to South Africa to deal with the documents. Now, please understand that there are certain ways in which our courts and our various government departments work with overseas documents. There's a manner in which we have to authenticate documents. The same applies to documents that we send overseas. So you need to be familiar with all of that. Now, before we go to even any of that, let's quickly look at what you need to have as a notary public. Once you pass the exam, you will then immediately contact the Legal Practices Council and start getting your papers ready, pay them the fee, find out what you need, what documents they require. Always ask them. They will provide you with the necessary. We have added that to our notes for you in our handout. So what you need to do is you need to be familiar with the various requirements. Now, the place where you practice will obviously be you practice within a jurisdiction of court in which you were enrolled, all right, or any other place in South Africa. And obviously with the Law Society, with the Legal Practices Council for the area for which you have been admitted. So you will need to comply with all their requirements. Now, you will recall from all the movies that you watch, all the old movies, they used to have seals and wax, and they put this blob of wax, they melt this blob of wax and put their seal of office on top. Well, good people, you now have a chance to practice. You have a seal of office. The seal of office embosses paper so that when you put your seal on the document, you can't remove that from the paper. It's very, very hard. That is your seal of office. So you will have to get yourselves a seal. Make sure when you get the seal, and it's very, very hard, Waltons are usually the only people that have these kind of things for you. They will have to print your details on. Don't forget, there is a further requirement that we have now. Not only does it have your name, a notary public, it also has to have your Legal Practices Council number. When you're admitted as an attorney and registered as an attorney with the relevant Legal Practices Council in your area, you get a number. That number has to go on it. I just put my number because I'm not going to change my seal after all these years. I just add it on by hand. But when you get your seal now, you can get it with the number. All right. So then you have to ensure now all your documents that you prepare, all your documents that are executed before you and which you attest to are public documents. Most of them, the majority of them, get registered at the deeds office. For example, your antenuptial contracts, your long-term leases, your notarial bonds, your servitudes. These are all documents that will be registered at the deeds office, which provides access to the public for these legal documents. You as a notary are obliged to keep what is called a protocol. This protocol has all these original documents in it. We will discuss which ones you don't put in, like, for example, where you confirm that something is a true copy of the original, or where you attest to the fact that your client's signature is the true signature of your client, for example, or bills of exchange. Those we don't worry about. And obviously, we no longer notarize wills and we no longer notarize trusts, so we don't have to worry about them. Unless, of course, you are doing an addendum to a trust that was registered notarially, okay, notarially executed and registered in the deeds office, that's a different story. But when we get to trust, we'll talk about that. So you have a protocol. Now, if you go to your local high court and go into the registrar's office and ask to look at a notary's protocol, all the notaries who have stopped practicing and those who have passed away, all their protocols, because they are documents, all their documents would get bound up in a book, and then they would be left with the courts. So you can look in there, and the way you have all your judgments, you have all your documents in consecutive order. You give them consecutive numbers, and they get displayed for life, forever. Most of your documents last in perpetuity, especially servitudes, all right? So you have a protocol. What do we do practically today? Well, I know I and a lot of my colleagues and our notarial practice colleagues get arch lever files with sleeves, and you put your documents. Top one is number one, and you usually, it depends on the kind of document you have, how thick they are. You can get between 70 to 100 documents in a nice big fat lever arch file. So that is your protocol. Then you have what is called a protocol register, and if you look at the documents, you will see in the annexures that we've provided, I've got these documents for you to give you an example of what it looks like. Again, you're going to have to order this from Walton's. I think they're the only ones that have it. It's a double page. You start off consecutively. A lot of my colleagues, especially those that have to deal with a lot of documents, will start off their document 1 stroke 2021. Next year it will be 1 stroke 2022 and so on. I don't do that. I just go from 1 to whatever number I've reached at the moment. So please, whatever you do, remember, you need a protocol register. What does this protocol register do? This protocol register gives the number of your document, the protocol number, the date it's executed before you. Now, everyone has to execute the document before you at the same time. Unlike documents that you would draft as an attorney, everything must be executed before you simultaneously. So the parties will sign, that is, execute the document before you. The witnesses will witness by appending their initials and signatures to the document that they have seen the parties executing the document. And then you will put your signature on it to attest to the fact that everyone has signed the documents and executed the documents before you. So this is the terminology. You attest, they execute before you. All right. So in your protocol register, you've got the number, the protocol number of the document, all right, consecutive numbering. You put in the names of the parties. You state what kind of document this is, an antenuptial contract, a long-term lease, a notarial bond, a servitude, whatever type of servitude. On the next page, it has fees. Now, we used to pay a variety of stamp duty on all our documents. Whether they were copies, we paid stamp duty on the copies, we'd pay stamp duty. Of course, the Stamp Duty Act is long gone, and thank goodness, doesn't create the problems we had in the past. However, please note that if you have a long-term lease which has not been registered at the deeds office and needs to still be registered at the deeds office, there might still be stamp duty applicable if it had not been stamped timelessly. We will talk about how you deal with that when we deal with leases. Okay, so you have a protocol where you put all the deeds, not all, only the deeds that you execute and lodge at the deeds office. Any certificate in respect of confirming any facts doesn't get a protocol number and doesn't get placed in your protocol register. Any document dealing with bills of exchange, again, same story. All right. So you have a protocol where you put your deeds in. You have a protocol register where at an instance you open your register and you can look up details. What I do is we also have a comments register at the end. So what I do there is once my document is registered at the deeds office, I'll put in registered dates so I know what date it's registered at the deeds office and the deeds office reference number. Now the deeds office has a whole lot of registers and they have registers. They give you a number for whatever document you lodge at the deeds office and you register. So I put that in there. Why? Because it's easy reference. You pick it up, you look at it, and you can see if a client needs something and they've lost something, you can give them the information. It also happens, we have a variety of programs available to us that deal with things like Deeds Web, Actex. They provide you access to deeds office information. Sometimes the deeds office information is not entirely correct on their system, but at the deeds office it's correct. So it provides you with a first stop in order to check information. You check information about your client, their ID numbers, do they have properties, are they married in or out of community of property, do they have properties, and all this information. We will talk about all of that as we go along. Now, when we have documents executed before us as notaries, and you need to start thinking about yourselves as notaries public, because what we're doing now is we will be organizing. I'm getting tongue-tied now. Please forgive me. I have a laptop that refuses to work. It works on everything except Microsoft, but never mind. So what we have to work with is you are going to create at least an original document and a duplicate document that you're going to get the clients to sign before you. The original, okay, is called the minute, and that will be filed in your protocol. The copy is called the gross. You can have more than one gross. And that document gets filed at the deeds office. That gets returned to you, stamped by the deeds office and everything else. And you then will take the information from that and put it in your protocol register and give the deeds office registered document to your client. When we're dealing with leases, we're going to have two grosses. Yeah, I know it's a gross way of discussing it, but what can you say? All right, so we have the minute, which is the original, and then we have the gross. All right, now we've talked about the protocol register, and we've talked about your protocol number. Now, let's talk a little bit about the Deeds Registries Act. Now, in terms of Section 102 of the Deeds Registries Act, that is the definition section of the Deeds Registries Act, one of the definition sections, and it states that a notarial deed means a deed attested by a notary public, but excludes any document signed by a notary public for the purpose of mere authentication of a signature of the deponent or a copy of a document which has been certified as correct by a notary public. So this is what I've been telling you. So that's in terms of Section 102 of the Deeds Registries Act. All right. So what is the function of a notary? As a notary public, you act as an independent person. You are almost on the level of a judge. And in the days long gone by, you would, a notary public, not you, obviously not you, because it was such a long time.
Hello, sorry, can I
Yes,
just interrupt you for just a second?
yes, of course.
I don't know if you are aware, but we can see your video and it's like moving all over the place.
Yes, unfortunately, I have to work with my cell phone. I can't work with my laptop. So I'm going to try, if you like, take a break and try and find a place to put my cell phone on so it doesn't move around. I will
No
try not
problem.
move too much. I'm so sorry. My
Change.
Microsoft Teams refused to work. So, you know, I've done that so many times. I've done this at least twice in two separate sessions, and I've never had a problem. And Teams refused to start up today, and it's still trying to start up. So if it starts, we're going to go back onto my laptop. But the problem, sorry, I'm going to try not to move this. But the problem is at the moment, I'm using my cell phone so we can do this. So please be patient, and I do
Sure.
apologize.
No
Okay, thank
problem.
you. Sorry, good people. And listen, normally you could send me questions, but I'm not too sure how it works on my cell phone. So may I suggest that if you have questions, I can stop in a short while and then you can just raise all the questions you have and I'll deal with them one by one, okay? But I do apologize. I will try not to move too much. Okay, let's talk about the responsibilities of you as notaries public. As I said, your office is a very, very old and archaic office. Archaic, hopefully not too archaic because, yeah, we don't want to be extinct. However, the problem we have is that our work has been eroded. So hopefully it will still be available. there is an international notary public organization, and we've had the privilege of meeting with them, and they have accepted that our qualifications are on par with theirs. So at some point in time, we are going to be working to try and get us recognized and to join their organization, purely so that you are in a position to receive work from overseas. And this mainly deals with authentication of documents. And people overseas, notaries public overseas, would prefer to deal with people that they are familiar with and whose level of education they accept and feel is of the same standard as theirs. And believe me, ours is of a very good standard. So you have nothing to worry about there. Now, as a notary public, the notary public that was first mentioned in the plakat. I don't know if you're going to all have to start digging deep. We're going back to years, your university years, and to work we did while you were at university, we all did. And you will find that we are going to be talking about things that you probably didn't expect we would deal with in these lectures. However, so the position of the notary public was almost on par as a judge. Now, what does that mean for you? It means you need to be impartial. You need to be honest. You need to ensure that your position as a notary public who's been attesting to these documents, before whom all these documents have been executed, your position is not compromised in any fashion whatsoever. So if you look at your notes, we've given you a whole lot of information pertaining to notary publics. We've discussed the admission of a notary public. Ethical standards, we don't look at the ethical standards of an attorney. Ethical standards are high up. You cannot be seen to have an interest in anything that you are attesting to. You cannot be seen to have a member of your family having an interest in anything you're attesting to. Doesn't that remind you of a certain governing party that we know of that has forgotten what it means to have ethics and to be impartial and to be in a position to stand up straight and account for yourself? Be that as it may, we don't talk politics here. We're just simply mentioning it. And while we're mentioning it, let's talk about something called the rule of law. I want you all to think about this very, very carefully. I know it was a concept that underlies everything we deal with as attorneys, notaries, and conveyancers. And I want you to look at the state our country is in, at the state our law enforcement is in, at the state of obedience of our laws. I mean, from the smallest minor, most minor law to the most major law. I mean, treason, anything you can think of, murder, Schedule 5 crimes, and think about whether or not there is compliance. Just take a road act, all right? That is the most simplest of examples. Do people stop at stop streets? Do people stop at red robots? Do people actually follow the rules of the road? Why do we have such a high death rate on our roads and such a high accident rate? And then decide whether or not you think there is a rule of law. You are the guys out there who need to ensure that it applies. And it applies throughout our legal system for every single law that we have. That it is not simply there for the convenience of certain people, and so that the poor have to comply and the rich are exempt. So please, good people, I'm not preaching here. This is a very serious issue that we need to think about as lawyers. This is a very, very serious issue that affects each and every one of us. We cannot be deemed to be upholding the laws of this country when no one is prepared to uphold the laws, where we have a country of lawlessness. Okay, enough said. I promise I will not raise this again. What are our ethical standards? The highest level whatsoever. It is absolutely essential, you guys, that we deal with everything in a manner that is honest, clean, clear. If you feel at any point in time, and believe me, this is going to be a problem, especially when you're dealing with antenuptial contracts and the drafting of antenuptial contracts. This is one of the best examples I can give you, where you will find that you will need to refer a client to someone else. If necessary, you can deal with one of the clients, but if you find that one of the parties is compromising the rights of the other party and they're not understanding what is happening and you feel there is unfairness taking place, then you are obliged to refer either one of the parties to someone else or both to different notaries. It is not a shame to have to do that. In fact, it is your obligation and your duty to do that. Okay, now let's talk about the Stamp Duties Act very, very briefly. This act has been repealed. However, there are some really rare instances where we might have to deal with this. And the best way of dealing with it is probably the only time that you might come across it is leases. And even then, what you're going to have to do is you will just refer it to SARS, South African Revenue Services, not the disease. And I know it's a joke, but at the end of the day, look where we are stuck with COVID-19. Even worse, I would say, than SARS. I don't know. Take your pick. But when I talk about SARS, I'm not talking about the disease. I'm talking about South African Revenue Services or the commissioner, whichever the case is. If there is ever a problem, you go to them. They will not, they don't use stamps anymore. They're no longer in vogue, obviously. But they will put on one of their stamps and they will write on it, and your clients will have to pay stamp duty and the like. Now, the first thing we're going to deal with, one of the first documents that you're going to deal with, and you find that you have to deal with these documents regularly, is authentication of documents and authentication of party signatures for purposes of using them overseas or for purposes of using them in South Africa, the said documents being signed overseas for use in South Africa. Now, there is the long way of doing things and there is a shorter way of doing things. Hopefully, you will end up having to deal with the shorter fashion as opposed to the long way of dealing with things. Now, what we need to deal with is authentication of documents for use overseas. Sorry, good people, let me just quickly organize my phone here. We have copies of documents for you. You will find that you're going to be asked regularly to authenticate either a document. It could be a document, it could be a record from a university. It could be documents by attorneys, for example, of admissions and attorneys and things like that. You need to look at the original document and you will prepare a certificate and say, I, the undersigned notary public of Johannesburg, province of Gauteng, Republic of South Africa, and you would also put in your, obviously, when you put in your name, underneath your name, you would put in your LPCM number, okay? Legal Practices Council, member number, okay? You will state that before me, personally, I was handed the original document, and I have compared this original document to the document which is annexed here to, and I confirm it is a true copy of the original. Note, you're not just a commissioner of oath for this. You're more than a commissioner of oath. It's not good enough just looking. You've got to compare the document, and you charge a fee for doing this, good people. All right. Oh, by the way, yes, before I forget. So you're going to get yourselves your seal of office. I also get a stamp because I find that if you're dealing with copies for company office documents, it's good to have the stamp as well. But you use your seal mainly because it embosses. Now, the little red wax that I was talking about earlier, we don't have a little red wax now. What we do have is a seal, one of these little seals. They come in a variety of reds. It comes in a nice bright orange red. It comes in a deep red, and it also comes in a metallic red. Which one are you going to use? I suggest the one that you find. I ran out of my nice orangish red because I don't like the deep one. And only one that I could find afterwards was the metallic red. So whether I like metallic red or not isn't a choice. So these are look like little round stars with serrated edges. You put it on your document, and then you put your seal of office on it. So it embosses not only your page, but it embosses this little seal, and you've got your signature further up, and that's it. So you stating on this document that you have seen the original, you've compared it to the documents annexed to your certificate, and this proves that it's a true copy of the original. You end it off, date it at whatever. You will see we have a lot of legalese for this. But for the exam purposes, if you get authentication of a document and you can't remember the terminology, just remember what information you need to include. That's all you have to do. And use short and sweet words and plain English, and you'll get past it. The examiners understand. They also don't remember all these things. They've got their precedents on their machines. Other thing I need to point out to you guys is you need to read in advance for all the lectures, plus read whatever we go through now. It helps. It makes a big difference once I've been through the lecture and you read through everything. Obviously, if you have questions, you're going to come back to me later and in the next lecture, and we will discuss it. I will also provide you with my email address. I think we're going to have to open new lights now. I will provide you with my email address. Sorry about the lighting. I will change it. And you're welcome to send me an email. I will try and get you a reply as soon as I can. Please understand we have a problem with internet in the area, and we have a problem with our cell phone lines. So the moral of the story is difficult to practice in Johannesburg these days. Okay. So now here's your certificate. It's authentication certificate. Just call it a certificate. I, the undersigned, you put your details, you put in your full name, you state what you are, notary public, you've got your LPCM number, where you're practicing. Obviously, if it's going overseas, it'll be Johannesburg, for example, province of Gauteng, Republic of South Africa. At the end of the document, you put in your full name, notary public, put in your LPCM number, your address where you practice, and remember your country. And that's it. So that's the first step for this. So you've authenticated this document. It same applies for signature. You get a client to come and sign a power of attorney in front of you, and all you're confirming is that you and the witnesses saw this person sign this power of attorney. And you've confirmed that this is the person, this person is truly who this person says he is. And the witnesses will confirm that they saw this person sign. So it varies. You can be amending a copy of a document that has already gone overseas. I've had that happening. Don't change the facts. Don't add anything that isn't there. Be truthful about every single aspect there and always compare the original to the copies. You charge a fee, never forget that. It costs money to buy these little things. You are allowed to charge for authenticating documents. How much? Well, it depends how many pages you've got and what the extent of your the perusal is that you have to do to compare. So, you know, based on your time and the amount of the documentation, you need to sort it out. Yes, you have a question. Hello, Rose?
Yes, I have a question. It's regarding authentication. Let's
Yes,
say there's a proof that a certain document exists. For example, in the university environment, that a certain certificate was issued to a graduate.
yes,
But now we don't have maybe proof because we don't duplicate it. Like you say, there must be a cruise and yes, minutes and what and something gross. Yes, minutes and gross. But in terms of certificate,
yes.
we don't have that.
And
So
no, 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 not for your certificates. So you just prepare a single certificate. It's not a minute and it's not a gross because the certificate of authentication. Sorry, Rose. Let me just. I think this might answer your question. A certificate of authentication does not go into your protocol, so it won't be a minute or a gross. All right, it's just a certificate.
yes, now can I please finish my question?
Yes, go ahead.
Yes. So now in a situation whereby yes, there is no a duplicate of it, and and in that case we don't have a copy, but we need to authenticate that yes, this exists. Can a notary do it in this case, in this instance, without seeing the original based on what is reflected on the record?
No. You need to look at the original. You need to have the original. Um, if for some reason the original cannot be found, then the university will have to provide something to state that, you know, we can't issue an original has been destroyed, whatever the case is, but we confirm X, Y, and Z, you know, that this is a true copy of the original. Then that changes things somewhat. But you can't certify something is an original if you haven't got an original. It becomes very difficult, but you can never authenticate something. You can authenticate it as a true copy of a copy, but you can never authenticate it as a true copy of an original if you don't see the original. Does that help?
Yes, thank you very much.
Pleasure. Sorry, Rose. Yes. Anyone else have a question? Someone? Hello? All right. Anyone else have a question? All right. Please make sure you guys switch off your microphones. Thank you. I can't switch everyone off myself. It's a bit difficult with the cell phone. Okay, so we've got the certificate of authentication. You are either authenticating, you can authenticate a copy of a copy, all right? You don't always necessarily authenticate an original, a copy of an original. Whatever the circumstances are, you just state the facts. You can't make up the facts if they are not before you. That's not enough now. You've prepared a certificate. Now you need a certificate from the next authority. And what is that certificate? It's to authenticate that you are, in fact, who you say you are, that you are a notary public and that this is your signature. All right. So, best bet is you go to the Registrar of the High Court. Registrar of the High Court, why? You can go to the Magistrate's Court if you do not have a High Court near you. The additional magistrate is able to do this. Obviously, when you get admitted, what you do is once you have your admission certificate and you have your stamp, you do letters to the deeds officers in your area, to the High Court, to the Magistrates Court, and you send them a copy or a certified copy of your admission document. proof of your signature and your stamp, and notify them where you're practicing and that you will be practicing in the area, so they have a record of all of this. And that way they can compare their records and see. In the deeds office these days, as a conveyancer, you always find a register. As a notary, you don't. In Pretoria, we get photographs and all sorts of other things. So just make sure you check with the authority in your area and see what their requirements are, because requirements change from day to day. And it's not necessarily statutory requirements, it's requirements to prevent fraud from taking place and to ensure that all the parties are genuine. Yeah, we have that as well. It's a big problem. So please bear that in mind. So what you do is, I find that the Registrar of the High Court has got a specific registrar's office that deals with authentication. So you go to the registrar and the registrar will prepare a certificate authenticating that you are who you say you are, that you're an admitted notary public in the area that you're practicing. Sorry, guys. Apologies. The phone, I'm trying not to move it. Yes, it gets a bit difficult not to move my hand. Then from there, you have to have the registrar's signature authenticated. Yeah, it gets very, very tedious. You have to ensure, we used to go to the Department of Justice, but now we don't do that. We go directly to Foreign Affairs, Department, what are they now called? In any event, you know who I mean. You need to phone them up. They also have a dedicated person who deals with this, and it takes a couple of days. So you understand now why it costs so much money. You're going to have to get couriers to take your documents out, to go pick up documents. My suggestion is that the first time you do it yourself and go out, you have travel expenses. Registrar of the High Court, you have different levels of registrars dealing with this. Some of them will deal with like authentication, getting you court orders, for example. They will confirm your signature, and then, or you will get an extract, get them to give you an extract from one of the court documents, and they will authenticate that it's a true extract from court proceedings, from a trial court proceedings, and the like. If it becomes complex, it needs to go to a higher level registrar in that department. So be very, very careful how you deal with it. And in your letter, you must always state which country it's going to and what you require them to provide. Now, you've seen it's a long process. In addition to all of this, once you have all these certificates, they get tied, notarially tied with this little green ribbon, which I might tell you, you can't get from Walton's anymore. Apparently, there's this little place in Lenasia in Johannesburg. I don't know, not Lenasia, I lie. In Fordsburg in Johannesburg, I still have to go there and see whether they still have, where you can get this green tape. You know the tape you use, that you used to use? You might not know, you're too young. We used to tie up council's briefs with green tape, and if it goes to senior council, it's pink tape, this like salmon-colored pink tape. Well, our notarial documents, if it's more than one page, we notarially tie them. If we have time, I don't know how I'm going to show you online how to do this, but I will show you pictures. I think I have got pictures for you, but what we'll do is I will try and see if I can video something and put it online and you can see how it's done. But I've run out of tape. So yes, I do quite a bit of authentication of documents. You know, clients need to use stuff overseas. So what can I say? The thing is, there is a convention that South Africa has become a party to quite some time ago. And it allows us, it's a Hague Convention, and it allows us to expedite this process. So instead of having to go to to our Department of International Relations, as they're now called, Foreign Affairs, whatever you want to call them, all we have to do is get this authentication of your signature as a notary public I usually go to the Registrar of the High Court, and normally we have an argument about which country is allowed or isn't allowed, but I will help you with that now. And they do a certificate called an apostille. Now, an apostille is based on the Hague Convention. It's notice, Government Gazette Notice R277, which is dated 3rd March 1967. It's a Hague Convention regarding the accession to the convention abolishing the requirement of legislation for foreign public documents. In other words, you do your certificate of authentication, either of a signature or of a document, and then that certificate, your signature, is authenticated by a document called an apostille. You will see we have an example of it. We've got 2 examples of an apostille for you in the notes and the annexures to the notes. Very, very important. Now, you're going to say, how do I know which countries are signatory to the apostille? There is a website, okay, which I'm just trying to see where I've put the website notes. Oh, by the way, we've got examples of certificate of authentications for you, and a certificate of authentication of your signature by the registrar, the notary signature. We've got examples for you, so just follow them, please. But the Hague Convention, we've got that in the notes, is www.hcch.net. You look under conventions status. Yes, there was a question. Rose. Hello? Okay.
It's regarding, I just have
Sorry.
today. I see here on our notes, it refers to
Sorry, I can't hear you. You're breaking up.
Can you hear me now?
Yes, better.
Yes, I'm saying regarding the in terms of rules, I see
You're
that.
breaking up.
Can you hear me now? Sorry.
Yes, you're still breaking up.
And now?
Yes, I can hear you. Go ahead.
Yes, with Rule 63, it's just on our notes. It doesn't have.
No. This is not Rule 63. This isn't Rule 63.
Oh, sorry.
What I'm talking about. Yes.
Yes, sorry. My bad. I just wanted to make a comment to say the Rule 63 is incomplete.
I haven't talked about Rule 63 yet. This has nothing to do with Rule 63. This is for documents being authenticated in South Africa for use overseas. We haven't gotten to Rule 63.
Okay.
Okay. All right, everyone. We're only dealing now with documents that are being authenticated in South Africa for use overseas. All right. Okay. We're all good. All right. So you either go by way of, you start off always with your certificate of authentication. Then there's a certificate authenticating your signature, followed with a certificate by the Department of International Relations authenticating the registrar's signature. However, if a country to which you are sending the documents is a signatory of this convention, which you will find in your notes, and you will also find online, it's in your notes, I've given you the address, it's the www.hcc.net address, okay? Now, if they are a signatory, you use an apostille, and that's where it ends. Now, your clients also need to understand that if it's going to a country where English is not an acceptable language, they will need to get their documents, all these documents officially translated by a translator that is acceptable to the embassy of the country to which this document is going. So that is not your job, that is their job, but that is what you have to do. Now, for documents coming into South Africa, being authenticated overseas, we have a High Court Rule 63 that was raised a little earlier. What does this say? This says you can circumvent a lot of the issues by following Rule 63. Now, Rule 63 tells you that If you send your client off, and now you have to be very careful. You send the documents, down the header draft certificate. You draw up all the documents and you send it to your clients so that your clients can get them signed. Your client can go to any embassy, consulate, mission of South Africa, and there go to the relevant person. They will phone them up. There are a number of people who are authorized to do this, and they will sign a document before this person, or will take the copy and it'll get authenticated before this person. And a certificate by that official is acceptable for use in South Africa. What happens if you can't find such a person? What are you going to do? Well, you have a bit of a problem. According to Rule 63, your client can then approach any embassy, consulate, or mission of the United Kingdom. And there they can have the same process, and a certificate by an official from an embassy, consulate, or mission of the United Kingdom is sufficient for use in South Africa. Practically, let me tell you where the problem lies. I had clients in Melbourne, and as a conveyancer, they had moved there, they had sold properties here, so I sent them a whole lot of documents. The only embassy, the South African has only got an embassy in Canberra. Melbourne has no embassy. So what did we do? So I said to the client, fine, I said, why don't you go to the UK? There is a UK, I think, consulate in Melbourne. So off I send my client, I give them all the documents, I give them all the things they need to do, what process they need to follow, because it's important they follow the process. You've also got to tell them they need to sign things in black ink, not in blue ink. And it's a whole rigmarole, but we'll go through the rigmarole. Guess what? My clients were South Africans. So they were told, terribly sorry, we can't help you. Despite the fact that we have a greater community belonging to the United Kingdom, they were kicked out. So what option did I have at that point? I said to them, please go to a notary public, get the notary public to sign a certificate, and then try and get an apostille at the relevant office. So I provided all the information I could. That isn't Rule 63. That is basically doing the reverse of what we did for any document going out. So although Rule 63 makes provision for alternatives, it is not always applicable. We aren't always able to follow the provisions of Rule 63. Now, let's talk a little bit more about Rule 63. If your client lives in or is in England, Scotland, Wales, Northern Ireland, Swaziland, Zimbabwe, Lesotho, or Botswana, they can go to a notary public there. And that notary public certificate is sufficient for use in South Africa. So there we have it, good people. And obviously, if your client is in the army, the South African Defence Force, they can go to a senior officer, and that officer's signature, authentication, and certificate will suffice as long as that person is a member of the South African Defence Force. So in a nutshell, that is Rule 63 summarized for you. The problem is you need to look at the practicalities of it, find out where your clients live, overseas, I mean. Are they close to any embassy, consulate, mission, South African embassy, consulate, and mission? Because that is the easiest way of dealing with it and the cheapest, because don't forget, even when you go to a consulate, mission, embassy, you still have to pay a fee to get these things done. And if they go to a notary, there's an appropriate fee as well. So bottom line, at the end of the day, you need to make sure that you give them sufficient details, find out exactly what they need to do, and instruct them and prepare documents and send it to them and ask them to print it and specify how it must be prepared. Remember, in Europe, for example, or not in England, but in a lot of the countries in Europe, they will prepare documents on the front of the page and on the reverse of the page. We don't use that. And that creates a problem here. So you've got to be specific about how they must print their documents, how they need to be signed, how they must be initialed. So that deals with authentication of documents leaving this country for use overseas and for documents prepared overseas for use in South Africa. Now, you will get a question on this, probably a 10-mark question. 10 marks is 10% of the paper. This is an easy way to score marks. It's not difficult. The only issue you have here is obviously the apostille is going to be a bit difficult to work with. But you've got to learn off by heart how to deal with it. It's not difficult. It's actually very, very easy. It's in point form. There are 8 points. You follow them and you just got to call it apostille. Please don't forget. I've got copies of everything for you. We've got them as part of the annexures and as part of the handout as well. I've attached stuff to the handout if I remember correctly, and you need to sort that. You need to go through all of that. In addition to all of that, we've given you a summary on the notary, the origins of a notary public, the modern origins of a notary public, because apparently they have actually found notary public stamps and seals that date back well over 2,000 years, but we don't worry about that too much. Now, there is another issue that I need to raise very, very briefly before we go into drafting of documents, and we're going to take a few minutes break so that I can plug in my phone. But what I need to raise is, how do you seal your documents? This is the practice that I've dealt with, and I believe this is the practice that is followed, that has been followed over the years. Now, most of the documents that you have to lodge at the deeds office must be initialed on the bottom right. All documents are initialed on the bottom right-hand corner of each and every page and signed in full on the page where everything is the signatures. So what I do is I seal, once everybody has put their initials on, my appearers, those are the parties, are the appearers. Well, they're not always the same people, but we'll talk about appearers now. The witnesses and my signature as a tester. I then put my seal. I don't use the little red thing. I just seal each and every corner of the bottom of each page. Why? Because once you've put your seal, you've embossed the page with the initials on it, which means it's very, very hard for anyone to defraud, okay? Or to change or to remove a page and change a page, which happens, unfortunately. And on the last page, I put my seal of office over my signature, okay? So you will see that that last little bit we've included is just confirmation where all of this comes from and why we sign our documents the way we do. Okay, anyone have questions so far? Are we good? Can I stop for a few minutes, please? Let's take a 5-minute break. I need to just quickly go and get my charger for my phone, and we take it from there. I'll speak to you shortly. Hello, everybody. Is the light very bad here? Let me change it again. This is wrong. Okay, hold on. I know I said 5 minutes. Okay. Oops. We did something. Rose, do you have a question? Can you hear me? Hello?
I think the hand is still up from the last time.
Oh, okay. All right. I thought, because I'm trying to see, I haven't used, sorry, good people, you know, this is actually quite an amazing thing to happen. I've never had a problem with this app before. It's ridiculous. It's not 5 minutes yet, is it? Okay, someone's recording. That's great. Can I start? Are you guys all back online? Or must I give it a few more minutes? Normally, okay, 1 or 2 more minutes. All right, everybody. I'm going to send you a message when we finish the lecture at about 9. I do apologize for that, but we will have to proceed a little longer than anticipated so I can get through some of the work that I've planned to deal with. Someone's asked if we are going to have a WhatsApp group. Yes, I don't create the WhatsApp groups. I know some of the participants do. Please ensure that you put me on the group. I will send you all my number and my email address later. And if you wouldn't mind putting me on the group, it also helps when we have issues with communication, which are unfortunately not far and few between, but far too many, I would say. Okay, good people. Now, this section that we're going to deal with now is basically a fundamental section of all our drafting. You need to practice doing your documents. Now, I've never had a problem with anyone in the exam except for one person. You know, you've got to learn to write fast. When you're answering the questions for the assignment and when you're practicing with the past paper questions, please make sure that you handwrite everything. You don't get computers in the exam. We're not that advanced. So the issue here is at the end of the day, you need to practice writing fast. This is a 4-hour exam. You get, I think, 15 minutes as well to enable you to type the exam. And the issue we have is you've got to write fast. This is an exam of between 5 and 6 or 7 questions with only a few short questions. And some of the questions are long. So the moral of the story is you've got to show the examiners that you know what you're doing. You time yourself. Don't ever go over time. Come back if you have to, but go on to the next question and answer as many questions as you can and do as much as you can. My job here is to show you how best to answer the questions with the time that you have available, and not how to show the examiners that you know what you're doing, but you ran out of time. Remember, they've been in your shoes before. They've written this exam. They know what it's like. I mean, I remember my arm fell off literally. When I finished, I couldn't move my arm. My elbow down to my fingers I was in agony. But it was a good exam. And that is something you need to remember. It's a far more straightforward exam, I would say, than conveyancing is. The knowledge you need to have here is vast. Conveyancing is massively vast. I can't, for those of you who have done conveyancing, you'll understand. For those of you who are going to do it, be warned. It is one of the most massive exams to write. And believe me, I've done a BSc for a year. And I still think the conveyancing exam was the worst. Why? Because there is so much that you need to know. And the same applies here. There is so much you need to know, but they rely on your drafting. So you've got to learn how to draft. Now, all our documents, well, the majority of our documents have a commencement. They have a little summary of what you're going to do and what you're about to do, like a preamble, so to speak. They have a body and they have an ending. If in the exam you follow the rules and you show the examiners, you know exactly how to draft a notarial document, what it needs to look like, give them details of what the document needs to be and the gist of the body, the nitty-gritty of the document, finish it off so you can show, and then just say ran out of time, you know. Give a little note, go back, do headings. We put headings in our documents. Why? I like headings. Not in my antenuptial contracts. I don't do headings in antenuptial contracts, but in things like leases and even in my notarial bonds, I put in headings. Why? Because in your wills, in trusts, your client, the person for whom you will be drafting in future once you're admitted, your client needs to have easy access. You know, they're not going to read through the whole thing. They want to look at the headings and see, yes, I want that. So they will go and look at that item and they will then deal with the question. So at the end of the day, my good people, if you show that you know what you're doing and you understand what needs to be done, you describe your parties correctly, you do your commencement correctly, you describe your property correctly if you're dealing with anything relating to immovable property, then you're halfway there. How do they mark the exams? Well, some people mark your document as a whole. Other examiners will give you marks for everything that you do right. And obviously will look and see that you've answered the question correctly and then will amend and change things accordingly. So I know one of the examiners who has retired, so she's no longer sitting on the board of examiners. I know quite a few. They all have their own ways of dealing with it. They all mark one question, the same question out of all your papers. So ultimately, at the end of the day, Make it easy for them. Follow the rules correctly and don't worry about saving paper. This is not the time when you're writing the exam to save paper and worry about trees. I worry about it. I'm one of the first people that goes into conservation. But believe me, follow what I tell you, do what I tell you, and if you've impressed the examiner with your commencement, with your understanding of description of the parties, and making it look good and showing the examiner, listen, you know, I have an idea of what I'm doing, you're halfway there. You've already got your 50% mark. Or maybe between 40 and 49, doesn't really matter. But the point is, you need to pass without an oral. And the objective of this course is that you pass without an oral. So, please, follow what we tell you. Look at the notes. Look at the examples we've given you and attempt the assignments. I know you don't have time. There is never time for anything once you're in the field we're in. But you've got to make the time. You've got to make the time to read through the notes once you've finished the lectures. You've got to make the time to go over the notes for the next lecture. You will find there are things you're not sure of, you don't understand. Once we go into the lecture, you will see everything falls into place and it makes it so much easier. And by reading through the notes after the lecture has ended, before you start on the new modules for new lectures, you are already halfway there. You're revising for the exam. And this is what you need to do. It's a constant revision. It takes time to get to the point where you know everything well. And it requires you to read through the documents and think of it as revision. Okay, now, in terms of the Deeds Registries Act, the majority of the documents that you lodge in the Deeds Office have to look in a certain fashion. So unless I tell you the opposite, all the documents that you're going to be lodging and preparing have to commence in this following fashion. You need to have space on top and space beneath. We've set it out for you in the notes. What is very important to remember is that your first page, you start in the middle of the page. In fact, you start below the middle of the page. Each document looks as follows. You've got this blank half page. On the right-hand side, at the bottom of that blank half page, you put in protocol number, NO. And that takes the number in your protocol register, the consecutive number in the protocol register. Next is you have a heading. Let's call it an antenuptial contract. All right. Beneath that, with or without the accrual, in terms of the Matrimonial Properties Act, in terms of the Civil Union Act, you will see there are options. You leave the space. Why? Because the Deeds Office does endorsements on the top of that page. There will be a stamp where the registrar will sign so that they can show and date. And that gives you the date on which your document is registered at the Deeds Office. On the right-hand side above your protocol number, they're going to stamp something called an H number, H1234/2021. That is a huwelijks contract, antenuptial contract. Yeah, it has an H. What can I say? A servitude is with a K, contract Afrikaans. If it's a sectional title servitude, it will be SK. A notarial bond is an NB, just to give you an example. A notarial lease is very interesting. It's a K. And at the end of that, after the year, we put an L, so we know it's a notarial lease. So there are different registers in the Deeds Office. Apologies, good people. I've got to just try and get my foot. Okay, sorted. So first page, you start in the middle of the page. So bottom line, what's going to appear on this page? Protocol number, the heading of your document, all right? And then be it hereby made known. Now, in the notes, we give you options for commencement. I like this. Why do I like this? because it's short and sweet. You can choose whatever you want when you're drafting your documents. In the exam, what are you going to do? The shortest possible commencement on the planet. Okay, good people. So then be it hereby made known that on this, the 29th day of July in the year 2021, before me, on a line of its own, your full names. Mine is Evangelia Skylarkers, as I'm registered. Yes, I know it's Litza Skylarkers, but that's my full name. Underneath my name, I'm going to put LPCM, and I'll put in my number. I don't know what my number is. Yes, I know. I've got it in the computer and it prints it and what have you. You make up a number. You make up a 6-digit number. Put in 07654, whatever. It doesn't matter. Just show. Before me, you put in your names. Now, when you draft in the documents, I want your names. You're going to say, I'm not a notary public yet. You're going to be a notary public soon. All right. Before me, notary public, duly sworn and admitted. All right. Because you're going to be duly sworn and admitted. Practicing at Johannesburg, province of Gauteng, personally came and appeared. All right, so what you're saying is this is your commencement. You've got the heading of the document, protocol number, be it hereby made known. And on this date at Johannesburg, you can put in at Johannesburg. It's fine that at Johannesburg on this, the 29th day of July 2021, before me, notary public, with your LPCM number, duly sworn and admitted, practicing at Johannesburg, province of Gauteng, personally came and appeared. Everyone personally comes and appears before you. Now we describe the parties. Normally, if you start just below the middle of the page, you'll only be able to describe one party. In our drafting with deeds, notarial deeds, you will find that we try and define everything we deal with. Why? Because number one, all our documents are public documents. Number two, everything relating to that act, that contract is in that contract. It's contained in that contract. We do not lead extraneous evidence to prove our documents. So what does that tell you? It tells you that your document needs to be a full document. It is complete. It has everything in it. Anything to deal with breach, anything to deal with dispute resolution, registration of the document in the deeds office. If you have to register at the deeds office, you say you're registering it at the deeds office. You state who's going to pay the cost of the drafting of the deed, who's going to pay the costs of registration at the deeds office. You do all of that. Oh, oops. Okay. Are you guys all okay? Sorry, I haven't seen your questions. I will try and get to your questions. Does someone need anything? All right. Okay. Sorry, good people. I'm trying to control this on the phone. It's not the same as on the laptop. Okay. So we have a document that is comprehensive, that has everything in it. And you need to ensure that is why your drafting is so important. We have short sentences, clear, concise sentences. You will see when we start dealing with servitudes, we don't usually have one servitude in a deed. We will have quite a few servitudes that relate to the same parties and the same properties. So we try and keep everything as clear as possible. We try and reduce the amount of ambiguity as much as possible. So you try and keep your wording precise. All right. Short sentences makes life a lot easier at the end of the day. All right, so what else is there? There are no implied, you try not to have implied terms. That's the worst possible thing to do. Everything must be set out clearly. Your language must be concise, precise. All right. We try and keep our typing acceptable to the deeds office. So the first page starts in the middle of the page. We've done the commencement, which we have in the notes for you, and you've got to decide. My suggestion is that you recite the commencement until you know it off by heart. Sing it in the shower. No one will hear you. Put it to a tune if you want to remember it. It's very easy. Then just remember everything we have to deal with. Don't leave blank pages or blank spots in your documents. Number your pages. The deeds office insists that you number the pages. You can only print on one side of the page. I've mentioned that previously. You put in the place and date of execution. Now, in your notes, you will see we've said no men whom it may concern. Be it hereby made known is the simplest. As a conclusion, remember I said to you, when you do your commencement, that on this day, you can state where you are. Alternatively, you could put in the place of signature at the end. So your conclusion, thus done and executed at Johannesburg on the date above mentioned in the presence of the undersigned witnesses, and you have as witnesses 1 and 2, and your appearers, your parties, and then underneath that, you have your signature as notary public in the middle of the page. You've got your signature. Quod, on top of your signature, you put in quod attestor. Before you are attesting to the fact, you are the notary who's attesting. You are signing, you're putting your signature down on the document to confirm that the others have executed before you. So it's essential. You never have documents signed before you at 2 different times, always done at once. Now, people will always appear before you personally, but they may do so either in their personal capacity or they may do so as a representative acting either in terms of a power of attorney or a resolution. All right. So when they are acting under the authority of someone else, nomine officio, then in your deed, once you've described the party, you're going to state and which power of attorney, certified copy of the power of attorney or certified copy of the resolution is filed here within my protocol. So what do we put in the protocol? Let's quickly, before we start dealing with description of parties, this is where we start. I said to you that your minute, which documents? It's your antenuptial contracts, it's your notarial bonds, your notarial leases, your notarial leases. Yeah, that's about it. And anything else relating to those documents that you deal with, any amendments, you can't really amend an antenuptial contract. You can't amend an antenuptial contract, full stop. You have to go to court to amend it. Yeah, that's the funny part. We'll talk about antenuptial contracts shortly, but what do you put in your protocol? You just put the minute and any power of attorney or resolution, any authorizing document that the appearer has utilized, all right, when they are appearing before you, the notary public, in a representative capacity and not in their personal capacity. Okay, so don't forget that. If ever you get stuck, that's what we do. Obviously, there are 1 or 2 other little items we add, but we will tell you as we go along. The gross will go to the deeds office. For example, the antenuptial contract, the minute goes into your protocol under number 1, and your gross will go to the deeds office, gets lodged at the deeds office, not by you, but by a conveyancer. And we have timing issues there that you need to be familiar with. Okay, so let's start on how we describe the parties. Let's deal with the parties acting in their personal capacity. And the people that we are going to deal with first are natural persons. And one thing you need to remember, if you're not the notary public, if you're not the conveyancer, and you're going to be using another conveyancer, and as a notary public, where you are conveyancer as well, you must always ensure that you comply with Regulation 18, subsection 3 of the Deeds Registries Act, which states that you as the notary public and the conveyancer will ask it of you, have to obtain an affidavit from the parties of status, okay, and solvency. So the affidavit says, I, the undersigned, so-and-so, confirm that this is my true name and identity number, and it also appears in this fashion as per my identity document or identity card, whatever it is that they've shown you. And then you state what the marital status is. I confirm that I am unmarried. And in the same affidavit, you state that I am not an unrehabilitated insolvent. This is a declaration your client makes. Or if they are, if there's any mention to them in any deeds registry, it is a coincidence and it's not them. Now, what is that about? Just to give you some background, it is important. Every deeds office has an office in it which deals with court orders in respect of attachments, sequestrations, liquidations, interim orders, final orders. Every single day, all these orders from all over the country get sent and delivered to the deeds office by the courts. The deeds office have books, and they put them in these books. They create books with them. Oh, they don't really do that now. Yeah, they still do it. You can still look up the court orders. You can't look them up online. You have to physically go in and look it up. So they will give it a number. Everything gets numbered in the deeds office. It'll get an S number, all right? If it's a sequestration, or if it's an attachment, it'll get an A. I think it's an A. I can't remember what it is. But if you do a deed search at the deeds office on a property, for example, on a person's name, it tells you which deeds office you can look it up. Say you're looking it up at the Johannesburg deeds office or the Pretoria deeds office, and you put in your client's name and ID number or the date of birth, and it'll give you a whole lot of details. The person is married, unmarried, they have a contract, an antenuptial contract, they have property, and there are various attachments, or there's a sequestration, and they mark it. Does it mean it's this person? No, it doesn't necessarily mean it's this person, but you take this reference number, which gives you a number and a year. You go pick up the book in the deeds office and you look it up. It's called an interdict. So it's called an interdict. Is it an interdict? Well, you can't transfer property. If there's an interdict, you have to go and make sure and give an affidavit, a certificate by the conveyancer to say it's not that person. Hence those affidavits in terms of Regulation 18 sub 3 that deal with all these things. So it's very, very interesting about sequestrations. People don't understand that to be rehabilitated automatically takes 10 years. Some of them think it's 5 years. Some of them think it's 6 years. You cannot get rehabilitated automatically unless 10 years have elapsed. And that creates a problem. And I will explain those problems to you as we go along. Now, how did we describe parties? Let's take a normal person. Right. We're going to deal with an unmarried person. John Brown, identity number, and we don't abbreviate, and you put in an identity number, unmarried beneath that. So you've got John Brown, beneath that you've got identity number, and you put in the identity number, and beneath that is unmarried. That is how to describe a normal person over the year, 18 years and above. What happens if they're married? That creates problems. You can be married out of community of property, which is wonderful because it's like being unmarried. So we can say John Brown, identity number, married out of community of property. Solves the problem. No issues there either. What happens if they're married in community of property? Major issues. You've got to cite both parties. So it's John Brown, identity number, and Maria Brown, identity number, married in community of property to each other. Now we've got to look at the Matrimonial Properties Act, Section 15 of the Matrimonial Properties Act, which says that if you're married in community of property, you have a joint estate. And either spouse to a joint estate has the right to deal with the assets of the joint estate equally. However, under certain circumstances, you need the consent of the other spouse to deal with an asset, usually immovable property. Now, whatever we deal with when it comes to notarial documents, the majority of the items we deal with relate to real rights. Immovable properties, servitudes are real rights, long-term leases are real rights. They become real rights once they're registered. Again, notarial bonds, we don't deal with immovable property, but that's another story entirely. But the point is, if you're married in community of property, the deeds office requires consent of the spouse. How does it translate? When you're drafting documents, you have to cite both of them. There are two exceptions to that citation. If one of the parties has inherited an asset, immovable property, for example, and in the will it says that this inheritance will not form part of the joint estate, then that spouse married in community of property will be dealing with that asset outside the joint estate as a separate asset. So how would you cite Mary Brown then if it's her asset? If you look it up in the title deed after it's been transferred to her, she's going to be cited as follows. Mary Brown, identity number, married in community of property to John Brown. That citation warns you that this is an asset that has been excluded from the operation of a joint estate. In those circumstances, you would have to get a copy of the title deed, which you can order online, and hopefully they are online, so you can get the online document. Yeah, that's another story entirely. And you look in conditions of title, and there you will see they cite the clause from a will that pertains to this exclusion. So all the information is available, but there are certain things that address this. Also, if you're married in community of property and as you are in business with someone else in a partnership, then the citation will be different. And remember, if you're in a partnership, you don't need the consent of your spouse. It's dealt with separately. So let's just say John Brown, identity number, married in community of property to Mary Brown, and Bull Black, identity number, unmarried, in partnership with each other, practicing under the name and style of XYZ partnership or something to that effect. Sorry, that's not the best example. Now, how do we cite parties that are married according to the Civil Union Act? We've got a big insert in the notes for you in that regard. If they're married out of community of property, it's not so difficult. We will describe them, and I'm going to cite this from the notes. Jack Willis, identity number, partner in a civil partnership out of community of property, registered in terms of the Civil Union Act number 17 of 2006. It's very, very important. This is the Deeds Office requirement for the citation of parties married according to the Civil Union Act. If they're married in community of property, it'll be Jack Willis, identity number, and Peter Brown, identity number, partners in a civil partnership in community of property. registered in terms of the Civil Union Act number 17 of 2006. Again, I need to remind you that you will not receive any legislation, any documents, any annexures that you would normally receive if you were dealing with the Deeds Registries Act, with conveyancing. So anything that you need to know, you have to learn. Do you need to learn off by heart? As long as you understand what you need to put in and you remember what you need to put in, you don't have to learn everything off by heart. Okay, so we've now dealt with unmarried person, natural person, married out of community of property and married in community of property. Now comes the difficulty. What happens if the parties are married according to the laws of another country? Firstly, let me reiterate something to you, because this is a difficult issue, and I have found that practitioners are missing the point, or they've become notaries without understanding the issue, or they've become conveyancers and have failed to understand the issue. I've come across it as a conveyancer tremendously, and the biggest problem is people will tell you one thing, but the reality is actually something totally different. You will ask for parties to provide you with documentation. Remember, you have an obligation in terms of the Financial Intelligence Center Act to get proof of address, ID. In addition to that, you need to get proof of marital status, documentation to support all of that. You need income tax numbers and the like, because in addition to the Regulation 18.3 affidavit that you have to obtain, you also have to obtain an affidavit in terms of FICA. Yes, what can I say? This is a requirement and it becomes even more onerous on your side. Yes, especially if you practice on your own, you will see what I mean when it comes to your audits. Fun and games with FICA. Yeah, I don't know sometimes if it's worth practicing. You spend more time with red tape and sorting out all these other issues for and on behalf of government, I might add, than you do anything else. And you have an obligation, and you can be held criminally liable if the information is not correct. So make sure you check everything, please, whatever you do. Don't forget Section 15 of the Matrimonial Properties Act. Be familiar with it. Please read through it a few times. You'll be fine. Now, talking about parties who are married according to the laws of another country. How do we go about resolving this? It's a big problem. First, you ask them to provide you with the IDs. Then ask them for the marriage certificate. Then ask them, you will see on the marriage certificate where they were married. Remember, if it is not a civil union, and it's a marriage in terms of the Marriages Act, you have to look to the husband's domicile at the time the marriage takes place in order to determine the laws of the country that will be applicable to the marriage. So, if your client is married according to the laws of England, but you see they provide you with South African IDs. They might even be South African citizens. What do? You ask the question. At the time when you got married in England, were you living in England permanently? Oh, no, we went on holiday because the family was there and we got married in England. So you were living in South Africa? Yes. And this is the husband now that has to answer the question. So if they're living in South Africa, which takes place in England, their marriage is not one out of community of property or according to the laws of England, which is what the law of England is, but it is married in community of property according to the laws of South Africa. So no matter what the marriage certificate says, if the husband was domiciled in South Africa, at the time of the marriage, South African laws apply. So please do not get your secretaries to do the initial consultation. You do the consultation and you find out what has happened. I am now faced with a situation where I've given an opinion and advice, and I've been giving this advice to these people for quite some time. When my client died, bought property, he was a South African permanent resident. For over 6 months, he had his permanent residence certificate, went overseas, got married, and brought the wife back here. They have a marriage certificate in Greece, but the Greek laws are not applicable. So they were married in community of property according to the laws of South Africa. It doesn't matter where you get married. It matters where you are domiciled. If you will recall your university years, law of conflict, that is very applicable. So what do? You make sure people give you the correct information. Because if it's incorrect, no matter what the documentation says, it affects the rights of third parties if you make such a mistake in any of your documents. And it is difficult to correct, especially when everyone wants to dispute everything. I mean, it's a factual thing. You can prove it. It's not difficult. You can get a court order. It's not difficult, but it's time consuming and it is costly. So the moral of the story is get people to tell you exactly what the situation is. Then the next question you're going to ask is, what about same-sex marriages? Very simple. If you are drafting an antenuptial contract, you must state whose country of domicile is going to be applicable to the marriage and which country's laws will obviously then apply. So set it up. You will see when we're drafting antenuptial contracts, when you start drafting antenuptial contracts, if you're dealing with a marriage in terms of the Civil Union Act, you ask the parties. If they both domiciled in South Africa, it's not a problem. But I would still specify which country's laws are applicable to the marriage. All right. There we go. It's a simple thing. So let's establish that the parties before you're married according to the laws of another country. Oh, and by the way, if you parties are married in the United States of America, your state, like the state of Texas, United States of America, because each state have their own laws. So please be very familiar with that. Okay, someone has asked a question. Let's see. So what happens if the partners do not have an antenuptial contract? Very, very good question indeed. Then you are in trouble. You will have to establish if they were both resident here. And if they're not, yes, if they don't have an antenuptial contract and they're married according to the laws of another country, then you don't have a problem. I'll show you how to deal with it. If they are married according to the laws of South Africa, and they're both domiciled here, well, you will need to speak to them and they need to make a decision. Yes, it's a very, very good question. Now, if they're married according to the laws of another country, even if it's a same-sex marriage, it's not a problem. It's only a problem when South African law should be applicable. If they're married according to the laws of another country, we now have to look at two scenarios. The first is, are they receiving rights or are they giving rights away? In other words, are they grantors or are they grantees? A grantor is a person who is giving something to someone and is giving rights. You will see we have funny little phrases. It's important to determine whether they are grantors or grantees. Why? If you are giving away a right, no matter what country they're married in, you don't know. Our deeds office doesn't know other countries' laws. They only know South African laws. So they say, if you are potentially giving away people's rights as grantors, You will need the consent of the other spouse, no matter how you married. Why? It's to ensure that if it is required, you've got the consent and nothing has been done that in any way affects the rights of the other spouse. If you are a grantee, you are receiving rights, which means you're adding rights to this potential joint estate. So do you need the consent of the other party? No, you just mention the other party. So let's see how we're going to describe them. It's not so difficult, really. It's the difficulty is just establishing the facts from the clients. A lot of people think they are married in a certain way and they're not. A lot of people, they think they're married with an ANC and the ANCs have not been registered. So they're not. Or the ANCs were registered too late, so they're married in community of property. So there are a lot of things you need to check. Let's do the description of the parties, and then I will tell you the documents that you are obliged to obtain in terms of FICA, in terms of Regulation 18, and for your peace of mind. Because at the end of the day, the buck stops with you, and you're the one that's going to be sued. So this is what you have to do. John and Maria Brown, married according to the laws of England. All right. So where they are grantees. John Brown is the person receiving the rights. So we're going to say John Brown, identity number, married, which marriage is governed according to the laws of the United Kingdom or England, United Kingdom. I think the laws in Scotland differ to the laws in England. I'm not sure. So according to the laws of England, to Maria Brown. Okay. What if he's the grantor? It'll be John Brown, identity number, married, which marriage is governed according to the laws of England, to Maria Brown, duly assisted by her where necessary. Practically, it means she's going to have to sign a consent, all right, which you will have to lodge at the deeds office to show that she has consented. Or she can sign a consent on your notarial deed. I don't know how you're going to put it there, but you can put it in. So there it is. Now, how do we describe parties who are divorced or who have lost a spouse and are widowed? We try not to differentiate. We try and be nice. We call everyone unmarried. You can call them a divorcee or a widow or widower, but we try and be consistent. I've seen the clauses. The deeds office prefers we call them unmarried if they are unmarried, and married if they are married, and we would have to describe how they are married. So what you need to do is you need to have antenuptial contracts and you need to have marriage certificates. For an antenuptial contract to be valid, there are certain factors that need to be present. We're going to deal with it a bit later, but I'll tell you right now. So these are the things you as the notary or conveyancer are going to look at to ensure that the parties before you are in fact married out of community of property with an antenuptial contract. With or without the accrual is irrelevant. We don't say that. We just say married out of community of property. You check the date on the marriage certificate. Then you check the antenuptial contract for three things. Number one, you check the date upon which the antenuptial contract was executed before the notary. That date must be before the date of the marriage, or on the same date. But if it's on the same day, then you have to specify a time to show that it was before. That creates problems as well. The next thing you need to check. So already, the first thing is the actual marriage has to take place after the antenuptial contract has been executed. Then your antenuptial contract must be registered at the deeds office within 3 months of date of its execution. Otherwise, it is not valid. And then you have to, whoever failed to register it timelessly will have to bring an application to the High Court for registration of a post-nuptial contract. You advertise to the world at large, and creditors. What is the registration process all about? All these public documents that we register are for third parties to determine their relationship, their contractual relationship with the parties involved in the deed that you've prepared. So we are looking at certainty for other parties. No, I better not say anything. Okay, so that is the situation of marriages out of community of property, marriages in community of property, as well as civil union rights, marriages, civil union, in terms of the Civil Union Act. There, we call the parties partners and not spouses, or you can call them spouses. We'll talk about that more when we do antenuptial contracts. But bottom line is, please just look at the notes. We've got long discussion on the Matrimonial Properties Act, and the parties in married in community of property and the consents that are required. Now, you will see we also have alternative wording for you in the notes. Ultimately, decide which one you prefer. The deeds office, what we've got in the notes is acceptable by the deeds office. Unless I provide you with information to the contrary, these notes were updated at the beginning of the year. So there isn't anything new other than the fact that every time we have a new budget speech, things change, and that will obviously affect minor things. So you must always, at the end of the budget speech, once it's been given a day or two later, you go on the SARS website and you look for the pocket guide to the budget speech. It's a 4-page thing, and it gives you an update on all the taxes that you need to be familiar with, like transfer duty, estate duty, donations tax, and capital gains tax, and all sorts of other wonderful little taxation things that you need to be familiar with. Remember, we are not registered financial services providers, although it seems we might have to start registering from the last that I read, but that's another story entirely. We give advice in respect of the law, and we draft documents based on the legislation that is applicable. We don't give financial advice. Our financial advice, so to speak, if one can put it that way, is limited to how the acts apply. We are not there to make money from the clients, from the way they set up things, like the banks and the insurance companies do. We are simply there to ensure that we've done our clients, we've justified our clients coming to us and drafting documents for them. Remember, please always check all your information and obtain everything that you need to obtain in terms of legislation. All right, now, we've talked about parties. Now, the other parties that we need to concern ourselves with is marriages in terms of recognition of customary marriages. I don't want to go into that just yet, because I want to deal with that when we deal with antenuptial contracts. But just be aware that you can also be married in terms of recognition of customary union act, and a registered customary union is a marriage in community of property, unless you have an antenuptial contract, which you may enter into as long as it's been entered into prior to the marriage itself taking place. We will talk about what constitutes the marriage having taken place as a customary union. Now, we've talked about partnerships. I said Peter Pan, identity number, married in community of property to Jane Pan, and Buck Rogers, identity number, unmarried carrying on business in partnership as Pan and Rogers. So I've explained the two exceptions to you. There are no other exceptions except for bad drafting. Now, we come to the biggest headache you're ever going to come across when it comes to describing natural persons. The last category of natural persons that we have to deal, second last category that we have to deal with is minors and unborn children. And the last group is people with limited capacity to act, not minors, but insolvents and people who are not compos mentis. Yes, that is a big issue these days. People live long, and unfortunately, there is a huge rise in the number of Alzheimer cases and the number of cases of senile dementia, and young people, well, relatively young people in their 50s get Alzheimer's, and it is very sad. And people will come to you and say, I've got a power of attorney. Is that sufficient? A general power of attorney does not work. And why? Because think about it. Here is a person who's given a general power of attorney when they were compos mentis, right? And now their ability to understand has deteriorated to such a point that they don't understand. There's a person here who's got a general power of attorney to act on their behalf. The problem is that they can't act on their own. They will go and give all their stuff away, give gifts to everybody, spend money, they become spendthrifts, all sorts of things happen because they don't have control. Does a general power of attorney supersede the act of having a curator appointed for this person? What does a curator do? A curator doesn't only look after that person's financials, but also that person's person, their well-being, everything. So I don't think a general power of attorney suffices. It might help in the beginning where they are not able to do too many things, but afterwards, that general power of attorney cannot be used. You need to apply to court to have a curator appointed for this person. This curator will look after them. You know, family members, unfortunately, you will find in practice, you will see, not necessarily from personal experience, hopefully not, but from general experience, being in a practice, when it comes to money, nothing else matters. So don't get pulled into these traps where they want you to drop powers of attorney, general powers of attorney. You know, we register general powers of attorney at a deeds office and they may be used and they continue to be in use. All right. However, in order to have them cancelled, you have to actually physically cancel them. A cancellation of a general power of attorney. All right. Don't forget that. They are valid. There is no time limit to them unless there is a time limit placed on the general power. So special powers are what we deal with mainly in all our notarial work. And you will see why sometimes it's not easy to have all the parties appear before you to sign a servitude. So you will attach to a special power of attorney the draft document that you've prepared. They will read it. You will go through it with the clients. They will authorize someone in your office to sign on their behalf in a nominal capacity. You will go through the whole thing with them and they will understand it. Remember, what is important today, especially nowadays with the National Credit Act and the Consumer Protection Act and all of that, but as a notary, part of your job as a notary is to ensure that your client understands what you have prepared and what they're signing. We're going back to the parties, but this is very important. The other very important thing is that you understand what the client wants. So the client, I want this and I want that and I want the other. Ask the client what it is that the client wants to achieve at the end of the day. all right? And by achieve, what do I mean? What is the end result? What does the client believe that by taking this step, this legal step, what will the result be? And you will find a lot of times that firstly, they've been listening to their friends and watching TV and they want to do things, and they're not understanding the fiscal implications, number one, or the taxes that they have to pay. For example, donations are the worst possible thing to do because they carry donations tax, and if it's immovable property, there's transfer duty, and there's capital gains tax if it's immovable property, because you will see as we go along and when we're discussing capital gains tax, a definition of capital gains tax, an asset, disposal of an asset. That is the magic phrase with capital gains tax, is disposal of asset. That definition is very wide and it covers almost everything you can think of. So you need to ensure that your client understands the implications of what they want, and you understand what it is they want to achieve without having to go to all of this rigmarole. There might be a very simple way of doing things. There always is. Okay, so minors are problematic because we have two types of minors. We have minors who are under 7 and below, and minors that are 7 and above. Remember, age of majority is 18. When a minor gets married, and in terms of the Marriages Act, a minor must be 16 years and above only to get married. To enter into a civil union and to enter into a customary union, you have to be 18 years and above. So, when a minor gets married, they automatically attain the age of majority. All right. You can't have an unmarried minor. A minor is unmarried, full stop. All right, a minor. If a minor gets married, they become a major. Then remember that you can attain majority by applying to court for emancipation. Okay, so if a minor has attained the age of majority through emancipation, you will need that court order and you will have to cite that minor. So that minor will be able to sign documentation, because through emancipation and obtaining a court order, that minor has attained the age of majority. Oops, sorry. Apologies, I just lost my page again. Now, there is a catch when you deal with minors. As a grantee, in other words, receiving a right, there's no problem in getting a minor, in receiving a minor receiving a right. Very, very simple. You just cite the minor as a minor, Mary Brown, identity number, a minor. What happens when the minor is a grantee? Difficult. Now, we have to specify as a minor from 7 years below. Obviously, a minor cannot sign or do anything. So you would have to get the guardians to act for the minors. So Albert Botha and Betty Botha is an example. In our capacity as guardians of Yanni Botha, either born on a certain date or identity number a minor. Now, if the minor is over age of 7, you can say Betty Botha, identity number, a minor duly assisted by her guardian. All right. Now, there's a catch with minors. You cannot dispose in any fashion whatsoever of a minor's assets without the consent, not just the guardians, all right, but if the value of the asset is 250,000 Rand and lower, you need the consent of the Master of the High Court. If the asset is valued 250,000 Rand and above, you need the consent of the High Court. In other words, you have to apply to the High Court. Practically speaking, in order to dispose of the minor's asset, you have a curator appointed for it on behalf of the minor. They will look at the facts and decide whether or not it is in the minor's interest to have the asset disposed of, sold, encumbered, whatever the case is, and only then can you do anything. So, what is the moral of the story? Do not place any assets in a minor's name. Why? Because you're going to be in big trouble at the end of the day. You won't be able to do anything about it. You're going to have issues. All right. Now, where you have children to be born, all right, you can grant rights to such persons, grantees. Then you will have to determine children born of a marriage or children born of a certain parent. Okay, there's a difference. And we've given you 2 examples of that. Anna Venter married in community of property to Hannes Venter in trust for her children born or to be born. And listen to this one. Pieter Koen and Annette Koen in trust for children born or to be born of the marriage between the said Pieter Koen and Annette Koen. Just to give you an idea of the differences. Okay, good people. Let's quickly talk about insolvent persons. Now, obviously with insolvency, if someone has been declared insolvent, you can look this up at the deeds office and you can obtain all this information and go to the interdict's office where they've got all these volumes and volumes of orders, court orders and what have you, and look it up and see whether or not it's your client. And then you've got that Regulation 18(3) affidavit. You look it up and see. A lot of court orders before did not have identity numbers. Now they put in identity numbers. I once had 6 sequestration notes and none of them applied to my client. You look up and you see which court it's in. Okay. You ask the client, did you live there ever? You look at ages. You know, there might be a middle name that is different and you need to be sure. I once came across one. I was doing a property as a conveyancer, and so I'm meeting with the seller, and I say to him, I've prepared these documents. You know, you prepare everything based on the information that they send through to you, and you sit down and you talk to them. And I said, right, have you ever been declared bankrupt? He says, yes. I said, oh, when? Oh, 6 years ago. But I am rehabilitated. But the problem was that whoever had dealt with this never asked the question and signed off on it. And no one asked him. He thought that he had been automatically rehabilitated. A bank had given him a bond for crying out loud. So I was stuck with a situation where now I've got someone who is insolvent. What am I going to do? Because this is a third party's rights that have been affected. There's a bank. Okay, who cares about the banks? That's not the point. The bank could be your client. But the point is, this was all wrong. And how did you correct it? Well, the only way you can correct it is get hold of the trustee. I spoke to the registrar. We had to go and get a court order. But the registrar was prepared based on the circumstances and the facts before him. He could see that where the error arose and where all of this happened, and the bank was complicit. I mean, they should never have granted someone who was insolvent, and they had a record of his insolvency, a bond. He was prepared to exercise his discretion. Look, the Registrar of Deeds has discretion. In many instances, except where the Chief Registrar has made a decision, we have Chief Registrar Conference every year, once a year, and they come up with this like big volume where we have CRCs and all sorts of registrars, circulars and what have you, setting out what they've decided to do about X, Y, and Z because there was a problem here and there, and they've decided to change this and change that and do this and do that. Under these circumstances, they usually don't have discretion. But the Act is very generous. It allows the registrar discretion, and they exercise the discretion frugally, but assist you wherever they can, especially in a situation like this. He said that if we could get hold of the trustee, and it was a company, and I promise you, it can be a headache. So that's why it's so essential you get all this information and you ask people. Don't give them the legal term. Find the colloquial term and discuss it with them and explain what each concept is. And that is what the National Credit Act requires us to do in many instances, especially with bonds, whether it's a mortgage bond or a notarial bond. You have to explain all these legal terms, the legalese, the Latin terms to people so they understand what you're making reference to. You and I deal with this on a daily basis. We are so familiar with all these facts. We forget that the people that come to us only deal with this once in a blue moon or once in a lifetime or once or twice or 3 times in their lifetime. They don't deal with these concepts on a daily basis. It becomes a problem for them. So you need to explain things. And this is what is so crucial in our field of work. Whether you are acting as an attorney, as a conveyancer, as a notary public, it is essential that you ensure that people understand. Why? Because if you've explained it to them, they can't sue you afterwards. Yes, that's always an important aspect. Don't forget that. Okay, so I managed to sort out this problem. The trustee eventually gave us a letter and confirmed that he could deal with this property outside the insolvent estate. And that is how we got past it. Obviously, with the great assistance of the Registrar of Deeds. I had to go and see the registrar, and he died recently, which was quite sad. There are some really wonderful people at our deeds offices. They're highly trained and they treat the deeds office as a business. And they will do whatever it takes as long as it's legal and as long as they are permitted to do so in terms of the Deeds Registries Act or the Sectional Titles Act. They will do whatever they are able to assist the man in the street at the end of the day. Because that is what our job is, theirs and ours, is to make life easier for everybody. So when we're dealing with an insolvent, obviously, once the court order is obtained, then the Master of the High Court will appoint the trustee or the liquidator, and then the property will be dealt with by the liquidator or the trustee. So please, I'm not going to go through all of that now. I just want you to have a look at that because I know we started half an hour late. So we're going to go until 9 o'clock. I wanted to, in any event, proceed until 9. Whatever I don't finish today, I will finish next week. But I do want you to please attempt the questions. There are 2 questions. One relates to an authentication and one relates to drafting of an antenuptial contract. I will go through everything with you next week. So please do attempt it and read through the notes for those of you who are not able to continue with me now. All right. So the property will revest to an insolvent once he's been rehabilitated automatically in terms of the Insolvency Act, or if there has been an offer of compromise, if there's been an application to court to speed up the process where the creditors have agreed to this process, and then that will be done. So we've given you examples of how to deal with it. There are 2 issues that you need to be aware of. Most of the time, when you deal with something, I will describe the parties for you and show you how it needs to be done in the document. As I said to you before, we will describe, I've shown you how to describe parties appearing in their personal capacity, and I will now show you how to describe parties appearing in a representative capacity. And I want to deal with the companies, close corporations and trusts, and this will also cover trustees for insolvent estates and liquidators as well. Remember any authorizing document, when you get appointed as a trustee, you will have letters of appointment as trustee, or curators, or executors. Those are the documents that authorize the party that is appearing before you in a representative capacity, and you will need certified copies of that with your minute. So it'll go in the little sleeve. I put in these plastic sleeves. It makes life easier, and my document doesn't get damaged either. You know how things stick. It can be awful when you print. It's up to you. We don't really bind our documents now and create books with them. We just keep them in files. Remember, they need to be kept in a place of security, in a safe, or in a secure, locked up area. Now, what about companies and close corporations? I'm just trying to, okay, yeah, we will discuss that just now. With companies and close corporations, obviously you will have a resolution. Either the directors of a company are going to be authorized to act. One director will be authorized by the board of directors, or they're going to be authorized by the shareholders. So what does that tell you? You need to see the company documentation, check to see whether the directors are authorized to act for this specific act, and whether your resolution is correctly given. Now, with the closed corporation, you obviously have members, and again, you have a resolution authorizing one party or the other. Now, just a little deeds office requirement, and obviously, these are all the little things you need to ensure you do properly in the exam. If you're starting, for example, an anti-nuptial contract in the exam, start on a new page, start in the bottom of the page. Why? You're not wasting paper. You can have as many books as you want to write in. You do this because you want to show them you know how to set up your document. All right. Margins, yeah, just don't write to the edge of the page. There's only one time that I've had someone whose writing was illegible. Got a phone call and says, you won't believe it, but I have been asked to go for an oral for the exam because they couldn't read his writing. So please, that's only one person in all the years that I've been lecturing, where my students have all, no matter how bad your writing is, people can read your writing. Just make sure that you write, practice your writing. We don't write anymore. We use our computers now, so it becomes a problem. Okay, right. I have to, my battery is running out. I haven't been able to, give me a minute. I'm going to just switch off sound and video. I'm going to move to a different spot where I can actually sit on a high chair and attach my phone to power. Hello, good people. I'm back. Sorry, if the light is too bright, I apologize. I'm going to try and sit back. Doesn't work. All right, let me turn around. Okay, all right. Okay, so we continue. Now, with companies and close corporations, please remember this is the way you need to describe them. A company is ABC Proprietary Limited, all right? No abbreviations are allowed. Now, with close corporations, it depends. For a time, it would have been ABCCC, all right? And then it became ABC Close Corporation. The current view is that if your holding document says CC, you can abbreviate. If it says close corporation, then you must state close corporation. So what can I say? Now, it's important when you're describing them, you're going to have close corporation. Remember, whoever is acting is acting. How we would describe them in the deed would be as follows. Personally came and appeared before me, John Brown. He been duly authorized in terms of a resolution signed at Johannesburg on 28 July 2021 by the directors of, well, it doesn't really matter whether they're directors, by ABC Proprietary Limited, registration number underneath that. Now, with companies and close corporations, you have to ensure that you place you have the registration number correct. Now, the first 4 digits are the year when the company or close corporation was registered, followed with 6 digits, which are the company registration number. Now, in the older companies, you will find there were only 4 digits. So you precede those 4 digits by zeros. And after that, you have a stroke, a forward slash, and it's your company type. 08, 07, 21, 23 being a close corporation, 21 being a company that has been registered and not for gain. So that is companies. Very, very simple, very easy stuff. Here, you obviously have to ensure you have a certified copy of the resolution as well as a certified copy of whatever it is you've got, the resolution, nothing else. And you need to keep in your protocol, you're going to put the resolution copy with the minute. In your file, you're going to have all the company documents that you require. For FICA purposes, you're going to have to get the auditors to sign documents. It gets very complicated. You will need to have proof of address, normally a certificate from what used to be called CIPRO, I can't pronounce it now, is sufficient. They show what the registered head office of a company is. That's all you're required to do. Now, another entity that we have to worry about quite a bit is a trust. We have inter vivos trust and testamentary trusts. We will deal with trusts next week, so hang in there. But with an inter vivos trust and a testamentary trust, we have a registration number from the Master of the High Court. When do we get this number? When the trust is created, the Master will issue letters of authority to the trustees. On that, it has a number. If it is an inter vivos trust, it is IT. If it is a testamentary trust, I can't remember what. Hold on, I need to look here. I can't remember what we prefix it with. I will confirm with you and send you a note online. Now, what I also need you all to do is on this system, oh no, it's fine, don't worry. I will ask Molala Tladi to send me all your email addresses, and then I can just add on if there's anything else I need to send you. Now, with the trust, the most important thing you need to remember is you need a copy of the trust deed. letters of authority, and you need to check to see that the trustees are authorized to act in terms of the letters of authority. The other item you need to be very clear on is the following. The trustees may never have their acts retrospectively authorized. All right. It is an act which is void ab initio. Remember that. So normally when the people come to see you to draft documents, they've already reached a decision and they will already have a resolution for you. In most instances, when you have a legal entity that is going to be one of the parties to your transaction. So if you find that the resolution is lacking in any way, you need to point it out to them and they need to correct everything and sort things out and come back to you with a new resolution. As long as what they did is authorized prior to the act taking place. Remember, with a company and a closed corporation, you can have retrospective authority. However, not so with a trust. Please don't forget this. This is a very, very big distinction. Now, we're going to be dealing with inter vivos trusts as well as testamentary trusts. And we will also deal with the drafting of testamentary trusts, obviously wills. So I will get to that a little later, next lecture. We also have to deal with bodies corporate. A body corporate is an entity that has been created by the Sectional Titles Act. There you have trustees that have been appointed by the owners, who are all members of the body corporate. Again, resolutions and acts must be authorized and must fall within the ambit of the act. There are two acts we are talking about here. Sectional Titles Act, we will see this when we deal with servitudes, and the Sectional Schemes Act, the recent act that came into effect in 2017. We have banks, we have associations not for gain that are not registered. You will need to look at their documents, their founding documents, to see who is authorized to act for them. Then we have the state. If you're lucky enough to act for the state or unlucky enough to act for the state, the Republic of South Africa, very far and few documents that we deal with. What we do deal with quite substantially in our servitudes, you will see we deal with municipalities. They are, municipalities are entities that have been created by statute. So you need to understand their description will depend on how the deeds office wants you to describe them, and obviously on their status. There are various proclamations made changing different area names. Remember, when you're dealing with deeds office documents, I mean, Pretoria is Tshwane, but we don't talk about Tshwane in our deeds. We talk about Pretoria and the Pretoria Deeds Office. So these are issues that you need to be familiar with, and make sure that you don't change names. Just check acts and check deeds office amendments and the CRC regulations and all of that. That's why they're so important, because we cannot change a name ourselves unless it's been changed in terms of legislation. Now, one other type of person that we need to deal with, desperately need to deal with, and that is a mental person. Okay. All right. My phone is acting up. Sorry, good people. Right. Mental patients. Now, a mental patient usually has a curator appointed to act on their behalf. So, how do we deal with them? Well, we have to refer to them. There is a court order, clearly, but once a court order is obtained, the Master of the High Court appoints a curator, and there will be letters of curatorship that are issued by the Master of the High Court, and you have to specify the number of the letters of the curatorship and the date of issue. and which master of the High Court issued them. So that you will pick up from that document. So what is your authorizing document? There is your letters of curatorship. And the same thing with letters of executorship and the like. So please have a look at the notes in our module 2. They set up everything else. Now, one other item we really need to talk about before I do a quick summary on antenuptial contracts and just get you some ideas of what you need to do for drafting, and then we will go into in-depth drafting next lecture. I am going to go until 9 o'clock next time at least, because I need to go through a whole lot of things that are absolutely essential and I need you to understand. Now, the property clause, do you need to understand how to draft property clauses the way we would do them with the precision we need to do them in conveyancing? No, you don't have to, because all you have to do is you have to look up a title deed and you will follow the title deed description. And if you're not conveyancers, you will ask a conveyancer and that will help. For exam purposes, what do you need to know? You need to know that the deeds office has different registers. Each deeds office has a township register, not each deeds office. There's a township register, a sectional titles register, and there are agricultural holding registers and farm registers. The Johannesburg Deeds Office does not have an agricultural holding and a farm register. That is all in the Pretoria Deeds Office. How are you going to know what to do? It's very, very easy. They, in a question in the exam, they will give you information. Where they don't give you information, you have to make up information. And we help you make up information. For example, let's do a normal urban township description. Earth 123, Yeovil Township. In the next line, registration division, capital I dot capital R dot. Now, what are registration divisions? We have maps of all the properties in South Africa and they're divided into registration divisions. And various divisions fall under various deeds offices. You don't have to worry too much about it. You pick this up. When you do a deed search, you will pick up a registration division. No matter what kind of property you're dealing with, it sets it out there. In your deed search, you will get the extent of the property, in other words, how many square meters it is. The only one that you can't really look up and get a proper description of is a farm. Farm properties, you really need to have the title deed in order to get the correct description. You can get away with a search for urban property and earth and for an agricultural holding, but you can't get away with it with a farm. So Earth 123 Yeovil Township Registration Division, capital I, capital R. Below that, province of Gauteng. All right. Measuring 500 in numbers and then in brackets in words, 500. And after that, square meters. All right. And the square meters, yes. And then beneath that, you state held by deed of transfer, capital T 1234 stroke 2000. All right. Sometimes I give you all this information in the question. If they don't, and you have to draft a document that pertains to a property description, don't panic. It's very simple. It's not difficult. Agricultural holdings, again, the same story. They all have to have a registration division. You always have to set out the province. You always have to set out the extent of the property. You say in extent or measuring, whichever you remember and you find easier. Then the only thing you need to remember is that farm property, agricultural holdings and farms are dealt with in hectares. So you have to put in hectares and comma and 4 decimal points. Oh, you're going to say, how are we going to describe that? We've got all of that for you in the notes. Sectional title properties and urban are in square meters. If you have a title deed that has anything that is not in square meters, sorry, I have to hold the phone like this, otherwise my connection comes out. My charger. So if you have a property that has a description that is in feet, square feet, in words, in English feet, there is a conversion at the deeds office, so you can get the conversion done for you. They can assist you with that, but you have to make sure that there's a reference in square meters or in hectares. Otherwise, yeah, we don't do acres anymore. We do hectares. So if you want to also describe a property as a fraction, like you are transferring a half share or a third share. Remember, when you're transferring property, you have undivided shares. You would describe it as 1/2, a 1/2, 1/2, and in brackets 1/2, share in and to of 123 Yeovil Township, registration, division, and the like. So it is not a difficult description. Now, what is very, very important is, depending what document we're dealing with, we are going to define everything we deal with. When we have a property, we will hereinafter refer to as OF 123. Why? Because it's easier. You don't want to have the full property description repeated over and over again. When you're dealing with a grantor or a grantee, hereinafter referred to as the grantor, hereinafter referred to as the grantee. As you will see as we go along, all our documents will require you to tweak your definitions, but you will always have definitions hereinafter referred to make your contract easier to refer to, easier to read, and simpler. Then we obviously talked about the special power of attorney. In the notes, we've got a draft special power of attorney. I think what I'm going to do is I will, not for the next lecture, but for the third lecture, send you examples of powers of attorney with, for example, we do have them on the notes, but I'll send you one of the latest ones I've got so you can see what I mean by the powers of attorney and how we change the power of attorney slightly. But it's usually a special power of attorney authorizing the person to act on behalf of this party. All right, the appearer will be acting on behalf of the party who assigned the power of attorney. Now, good people, the one thing I need you to know is in Annexure 2.1 of the examples is a power of attorney to give you an idea of a special power of attorney. Are you going to be asked to draft a special power of attorney? You never know. You might be asked. Yes. Question. Angel, I think it is. What is your question? Okay. Let me have a look and see if someone's typed a question. Oh, all right. Okay, no problem. Whoever has a question, please just give me a few more minutes and then we can talk and you welcome questions. Okay, so the issue is, if you know how to describe the parties, and you will see it all seems as if it's now just something that is in the air. It's not. We're going to be dealing with that in great detail, and I will show you how everything comes together. Now, antenuptial contracts, as you know, and I'm going to be very brief here, very, very quickly, so that you have an idea of what I need you to go through and understand. We have basically three options available when you get married in South Africa. You can get married in community of property, which isn't a good idea. Why? Well, it's share and share alike, but you share in the debt as well. And if on insolvency, the joint estate becomes insolvent, which means all the assets of the parties fall in this insolvent estate. And it creates great hardship, especially if you have children, and it's difficult. We then have an antenuptial contract. without the accrual system, which what is yours, and what is mine, and that is how the rest of the marriage operates. Normally, what I tell my clients is if there are too many arguments about what they want to include and what they want to exclude for purposes of calculation of the accrual, and we will talk about that in length in the next few minutes. What I tell them is do a straight ANC and then have wills and deal with everything in your wills. Remember, the right of testation is absolute in South Africa. You're not obliged to leave anything to family members. You can do as you please as long as it's legal in your will. And you can even voice your disappointments. I have lots of clients doing that. And the third option you have is, which is, I think, the best option, especially for newlyweds and people who haven't been married more than once, young people who are starting a life together and are going to be building up everything together, is to get married with an antenuptial contract with the accrual. What does it do? During the marriage, it allows you to have the benefits of the marriage out of community of property, and whatever you build together on dissolution of the marriage, whether it's by death or divorce, to share in what you've built up together. So during the course of the marriage. So this is, I think, one of the better options. There are a few provisos and a few difficulties that need to be raised, but ultimately at the end of the day, most people want to get married in community of property. So this is the best option, bearing in mind the way the world works, the uncertainty in everything that is happening today in economics, and to try and actually protect one of the spouses to ensure that they don't lose everything. So it is very, very important that you explain to your clients when you first meet with them what the options are that they have available to them. And then they must tell you what their vision is of their marriage together. Unfortunately, a lot of these consultations end up in arguments because people aren't always sure what they want to exclude, what kind of assets there are. So you need to explain to people, if you're going to go by way of an antenuptial contract with the accrual, you need to ensure that you look at assets as follows. We have assets that you have before you get married. If there are substantial assets, then, okay, someone wants to know, are we going to deal with a pactum success? Yes. I will talk about that, yes, next week, if you don't mind. This is an important question. Yes, that is a big issue. Let me tell you why I don't want to even raise it now, purely because if I do, I just need to try and get some of the essentials of an ANC, and then we're going to deal with that. I actually even have a question that I'm going to send out to you all dealing with the issue that has just been raised in the handwritten question, in the typed question. So before I go and even worry about that, let's deal with assets. If the parties, when we look at assets, we look at a net asset. In other words, we take the value of the asset less any debt on the asset. So if they're coming into marriage and they've got nothing, they've both bought a car and it's fully on, they have taken out a contract with the bank to pay for it. So in other words, the minute they drive out of the shop, their car has lost value and they still owe their money plus interest to the bank, the value of the car plus interest to the bank. So from that, you can see we have assets that they will be accumulating over the years that are going to be increasing value, very few increase,